Hi, I really hope you enjoy this educational video. My name is Mark Byelich. I'm a certified financial planner, and my team and I focus on developing tax efficient or tax-free retirement strategies for our clients. We also focus on investment strategies that allow folks to eliminate the worry and have the potential growth that you need in retirement. So enjoy the video, and at the end, I'll tell you how you can schedule a no cost, no obligation consultation with me. Enjoy. And it is going to be recorded. I hope you're okay with
Fine.
it. Yeah.
Of course.
All right. Well, hey everybody. It is a few minutes before we're going to start our special webinar. We have Bryan Adler, an elder law attorney, with us again. And Bryan's going to go through a lot of information. We've got quite a few people signed up, so just going to let everybody come on. Bryan and I were just chatting about Veterans Day and how important that is, and we want to thank all the veterans out there. And as you're logging on, if you're a vet, raise your hand for me. Nobody. Or you're shy about it.
How about also if you're a vet or if you were married to or related to a vet?
Yeah, good question. So you should be able to raise there you go. Now we have a couple people raising their hands. Well, thank you for your service and your family service.
Indeed.
Yes. My daughter's 14, and she said, it seems like there's a Veterans Day every couple months. And I explained to her the different, Memorial Day, Veterans Day, Armistice Day, Armed Forces Day, and what's the fourth one I'm missing? I'm not sure, but they all have different meanings, of course. And I was explaining to her what it was. So it was a nice conversation to have. But we appreciate everything that everyone's done. All right, I'm just going to lower the hands. Okay, so many of the folks, if not all of them, that are going to join us tonight, Bryan, have been on my webinars, have probably been in the advanced class that you did with the estate planning. Mm-hmm. So they're all webinar veterans themselves. So we're going to go, I'd say max an hour unless there's a lot of questions. And we know, of course, people are going to have an opportunity to follow up after if they'd like with either you or me, and have their individual questions answered.
Of course.
But, folks, Bryan and I were just talking about how helpful these webinars are. So obviously I'm sitting in my home office. And Bryan, you're at your office, right? One of your offices?
I am, and I will tell you that the janitorial crew may come through, so I'll apologize in advance, but they tend to come between 6 and 7.
Okay. Where are you, in Trevos or?
Yeah, at the Neshaminy Interplex.
Because how many offices do you have? 4, 5?
3 in PA and 3 in Jersey. So we've got one in Radnor and Center City, and then 3 at Princeton, Cherry Hill, and Turnersville.
Okay. It's something. I wonder if, do you think you still need all those office locations now that you're so used to working remotely?
We're having those discussions now. Not only are we in the office less frequently, we're helping people way outside our geographic range originally. Sure. I'm meeting with clients in Wilkes-Barre and Scranton today that I can help. And we're thinking about shrinking some of those presences, still having something, just not quite as expansive as it was, because still, I think that over the next 5 years, we like to have short memories about these types of things. Mm-hmm. And hopefully we will have short memories about how terrible this has been. But I imagine in the next 4 or 5 years, things will get back to some semblance of normal, and we'll still be offering Zoom so we can expand and work with more people and help more families. But I think people want to be face-to-face more frequently as we start to come down from this. At least I hope so. I miss that.
I do too. I do too. I miss seeing people, but I have to tell you, these Zoom meetings are just so darn efficient. They are just really efficient. You can get a lot done in a short period of time, and you don't have the traffic issues. So that's right. Yeah, there were certainly some silver linings to everything that's going on.
Think about if we were doing this in person, we would have had an hour on each end to get there, get set up. It's a half a day. Here we can get a lot more people. Everyone's comfortable. Mm-hmm. I can wear sweatpants below the screen.
Nobody wants to hear that.
My law partner always wears shorts with shirts like this because he's only on Zoom, and occasionally he'll pop up during a meeting and everyone has to scream at him, "We don't need to see that, Jerry. We don't need to see that."
Well, one of the webinars we did in June or maybe May was with one of my favorite people in the financial services industry, David McKnight. So David's the author of a book called The Power of Zero, best-selling author. And he's, I guess David's in his mid 40s, but he's on his fifth or sixth book. And he's really just a super bright guy. And he and I become really friendly, and he's a great colleague. But he lives in Puerto Rico. He moved from Wisconsin about a year and a half ago to Puerto Rico. Yeah. He, his wife, I think his 7 kids, all moved to Puerto Rico because there's some amazing tax benefits to moving to Puerto Rico. So we were doing a webinar one night, and his lights automatically turned out behind him. So it looked just like he was sitting in a black cave. So we got up during I guess a break. Maybe I was talking, he wasn't talking. And he had a regular shirt on like this, and then he had his shorts. And it's just funny when you see it.
It's true.
That's acceptable in Puerto Rico. All right, it's 6:32, so we're going to officially kick off. I think most people are logged on. So hello, everybody. And again, welcome to Wednesday evening at 6:30 on Veterans Day. And thank you to all those veterans out there. I appreciate your service and everything you've done. And as Bryan said, the family members of veterans as well. So this is going to be a lot of fun. You all, I think, have heard Bryan before, or many of you have. So Bryan helped us with one of our advanced classes. I don't know, a few months ago now. He did a really,
it was like
really
May or April.
It may have been. It's time for another advanced class. And I have a series of classes coming up I'm going to talk about in a moment. But I would just want to remind everyone that you're muted, right? There is a Q&A at the bottom of the screen that you can press. It's a green box. It should be a green box on your screen. And if you have questions as we're going, just write your questions as we're going, because if you hold them to the end, maybe you might forget or something like that. But if you're worried about your question being answered, don't worry about it, because if it's answered and you hear it, just say, oh, I got it, or whatever your version of that is. If not, we'll just review it again, because there's nothing wrong with hearing things 2 or 3 times. These topics are very, very important, and sometimes they're very confusing, and that repetition can be good. So tonight we're going to talk about, it's really a spinoff of a conversation Bryan and I had a few weeks ago. It's Revocable Living Trusts versus powers of attorneys and transfer on death. And I'll just give you a little bit of background before I introduce Bryan. I was meeting with a client, and the client said, Bryan was great. Really appreciate everything he did for us with our wills and our documents. And he recommended a revocable living trust. And what do you think about that? And I said, oh, that's interesting. I don't know why he would have recommended that, but let me ask him. So Bryan and I had a conversation the next day, and he had some really, really good thoughts that were different than what I was thinking. And as we're talking through it, I said, Bryan, this is a great opportunity for a webinar. We should have this discussion with others, because this is a rich topic. So here we are.
Yeah.
So we're going to get started in a moment. I was talking about David McKnight, and just a little commercial. I do have David McKnight joining me on January 16th at 6:30. He's going to be calling in again from Puerto Rico, and he's going to talk about his new book. We're going to have that banter back and forth that everybody likes. And I do have classes starting on November 30th. There's going to be a series of 2 sets of 3 classes, Monday evenings and Wednesday evenings. They're going to go from 6:30 to 8:30. So 2 hours apiece, 6 hours of instructions. So over the past 2 weeks, I've focused on, and you've heard me talk about the team, and Bryan and I were talking before the webinar about this, and you really need a team to have the best opportunity for your retirement or your financial future to be successful. So that team should be a certified financial planner, in my opinion, qualified certified financial planner, a CPA or a tax preparer. I prefer a CPA. And at least one attorney, and at least you need a good estate attorney. And if you are considered elderly yourself, and even if you don't want to admit it, you might be considered elderly yourself, or if you have parents who are elderly, or someone you care for who are elderly, I suggest that you also have an elder law attorney. And most of the time, that estate attorney and the elder law attorney can be the same person. But I always caution, you don't want someone who also does elder law. The person who will help you with a speeding ticket and also help you with elder law, or will help you with a slip and fall and also do elder law, because it's a very specialized field, and it's full of landmines, not just speed bumps, but landmines. So that person has to be very specifically trained and qualified. And Bryan is certainly one of those people. So that's the team you want to put together. And those folks, whether they're 3 or 4 or 5, should all work together closely for your benefit. So Bryan, I've known for quite a few years now, and I'll just tell you, Bryan is a certified elder law attorney through the National Elder Law Foundation. The National Elder Law Foundation is the only American Bar Association accredited certification in elder law. Bryan dedicates his elder law practice to advising and counseling clients in the areas of elder law, life care planning, asset protection, veterans benefits, estate planning, guardianships, and long-term care advocacy for both Pennsylvania and New Jersey residents. We talked a bit about all the offices Bryan has with his law firm, and there's a lot of accessibility, certainly in PA, New Jersey.
Mm-hmm.
Bryan, that's the introduction. I just want to give you a moment to say hello. And as
Sure.
Bryan's talking, I'm just going to ask you folks, because Zoom is a little crazy sometimes. I just want to raise your hand if you see me and Bryan on your screen. No, you're just seeing me. Raise your hand if you're just seeing me. So Bryan, let's sing a couple bars of your favorite song, and we'll see. I'm just kidding. But
You guys would go deaf. Your ears would bleed.
Okay. So hopefully you're seeing Bryan. But so I told you we were having this conversation about the Revocable Living Trust, and we talk a lot of it in the class about TOD, transfer on death, and POD, and how you can set these up. And in Pennsylvania and really New Jersey as well, I always said you can really do effective estate transfer using these tools, and you may not really need a revocable living trust. And then I had this conversation with Bryan. So Bryan, I'm going to let you take it from there, because you started talking about some of the reasons and really what changed your mind about it. So give some background on that, please.
Of course. So, I came up as an elder law attorney, as an estate planning attorney, and I was taught, and my experience supported that a power of attorney and transfer on death beneficiaries were sufficient to effectively transfer wealth in the most efficient manner. It was kind of drilled in my head that you don't need revocable living trusts unless you have some unique issue, out of state real property, meaning, like a New Jersey shore house or a Florida shore house, or you have an unusual family dynamic, something like that. But about a year and a half ago, almost 2 years ago, I participated in an elder law discussion with the Pennsylvania Academy of Elder Law Attorneys, and a friend and a colleague of mine, Julian Gray, who is an elder care attorney in Pittsburgh, led a point-counterpoint with an elder law attorney from Central Pennsylvania. And they said Julian was an RLT, a Revocable Living Trust supporter, and the counterpoint, her name's escaping me, was a POA only. And I was falling all over the side of POA only. And then, I listened to Julian, and he had some key points. Still didn't change my practice, though. I still only recommended RLTs in certain circumstances. Then COVID hit, and I had close to a dozen clients that had passed away. And these were existing clients that we were doing life care planning for, and care coordination, long-term care planning. They passed away suddenly. And probate was frozen. The registers of wills were shut down. We couldn't get access to funds to pay inheritance taxes. So there were times where we lost down to 5% discount. We couldn't get access to funds to pay real property taxes, and it was all delayed. And I kept thinking to myself, had we used a revocable living trust, we wouldn't have had this issue. We could have gone right to the bank and started writing checks. That was what started to change my viewpoint. And when I was sitting with clients and discussing with them the value of an RLT, and Mark, I mentioned this to you when we spoke of the clients that we are working with together. When Mark called me and said, what was the purpose here? And I'm very clear when I discuss this with clients. I talk about will and powers of attorney with beneficiary designations. I talk about will, powers of attorney, and revocable living trust. And I explain to them what the differences are, and I offer what the difference in price is, because there's an added cost there to do a revocable living trust. It's more complicated, and I let the family make the decision because I want them to have all the facts. There are some practitioners that will say you need a trust or you don't need a trust. I think you need to be provided both of those. And since COVID hit, my viewpoint has evolved. Now, Mark and I were just discussing tonight, my viewpoint is continuing to evolve because of the problems I've been encountering with powers of attorney. You got to have them. There is no question. The most critical documents that you can have are financial and healthcare powers of attorney. There is no argument with that. No one can argue you don't need them. But if you have them and you have a revocable living trust, the trust itself, if done properly, if funded properly, can grease the skids. It can make things much more manageable. It can ease access to funds when needed, particularly if there's some sort of cognitive incapacity or some sort of healthcare crisis.
Okay. But that really sets a stage for the discussion, because that's what made me say, and of course, folks, I wasn't being accusatory of Bryan. I just called him. I remember I was driving to actually meet a client for one of these Medicaid compliant annuities that I do for different attorneys, which is really more of a passion than anything else. But and we were talking about this process on the while I was driving to the house, and I was kind of complaining to Bryan about the problems we were having with the power of attorney and getting the power of attorney to be able to meet and execute these documents and do all those things. And he says to me, you're kind of making the case for it right now as right. Well. So I'm going to launch. We put a couple polls together, and I'm going to launch the first poll. And I see a question. I'll take that in a minute. But the poll is going to be, what legal documents do you think are important? I'm going to launch the poll, and then I'm going to read it to you. And we have your will and power of attorney. And I just want you to choose one, right? Whichever you think is the series, or one that you think is most important. So will and power of attorney, will, power of attorney, and a revocable living trust, or a will, power of attorney, revocable living trust, and a living will, which is a healthcare power of attorney. So I want to make sure that you can all see that poll. Raise your hand if you can see it. We only 5 people have responded. Response is mandatory if you want to get the credit for this class. Just kidding. I was on a training event last Thursday and Friday. Ed Slott, their master lead advisor training course. We have to attend these twice a year, and they're usually in great places. And this year was supposed to be in Las Vegas. I was planning on taking my family with me, so I was disappointed. But they started having these polls in the classes, so that you to get the continuing education credits, you had to answer them really quickly. And I at one point I had to run into from the kitchen back into here to make sure I answered the poll, because you don't want to sit there for 2 days in front of your computer and not get the continuing education credits.
Mark, they do this at CLEs for continuing legal education, only they announce random 5-digit codes at unknown intervals. So if you happen to take a bathroom break, you could miss a code.
Well, I think that's deserved, because CLEs are about the worst. I do. Well, I haven't done it in about a year or so now, but I do some training at the Bucks County Bar Association. I do a CLE about fiduciary responsibility, and I'll say that I always get good reviews, and they've actually. I had one woman say in one of the reviews that this is the only CLE I've ever paid attention to. And I just couldn't believe she wrote that down.
I've had people I've watched people do the crossword puzzle. They've had the newspaper fully open on the table. I mean, they just don't care.
Right. Nothing's worse than attorneys and CLEs. Okay. So I'm going to end the polling. We had 20 people answer the question, and everyone said, Bryan, can you see the poll?
I can see it, but I can't vote.
Yeah. Okay. So everyone said, legal documents that you think are important are will, power of attorney, revocable living trust, living will, and healthcare POA. Really interesting. All right, I'm going to.
Which, in fairness, I think we put the cart before the horse there.
Yeah, maybe.
But that's okay, because it's about what they take away from this, not necessarily what they knew when they were coming in. But I hope you get from that, because that's the right answer.
So Howard, I see your 2 questions, and I'm going to just put them on hold for now, unless Bryan, you want to take those now.
It's your call. I'm following you, my man.
Can you see these? The questions?
Let me see. Let me take a peek here. Oh, these are actually, I mean, we're going to get to these.
Right. That's what I
Yeah,
thought.
Howard, we're going to answer these over the course of our discussion.
Okay. All right. So I'm going to go ahead and launch Brian's PowerPoint. And let me just make sure that everybody can see it here. You should see something in front of you that says Rothkopf Law Group, Elder Law, Elder Care Law. If you have that, if you see that, please raise your hand. Okay, good.
And I see it too, Mark.
Great. Thank you, Brian. All right. So Brian, I'm going to let you continue and I'll just interrupt you as I need to. Is that okay?
Yeah, absolutely. So let's go ahead and skip a slide forward, see where we're starting.
Okay. All right.
Keep going.
Keep going. Okay.
Okay. So you can bring up that whole slide there. There's a couple of bullet points. There you go. So let's put some foundation here.
Okay.
We got powers of attorney. That's, I mentioned, the most critical document because you need someone to make you need to appoint a surrogate decision maker. You as the principal need to appoint an agent to make decisions for you if you can't make it yourself. The challenges to its use, though, with powers of attorney is filing it with banks. I serve as the agent under power of attorney for a good deal of my clients because they are what is referred to as unsupported elders. They don't have anybody else to help them with their affairs, whether it be daily money management, financial decision-making, bill pay, things like that, or healthcare decision-making. So I know what it takes to put these powers of attorney on file at banks. It's difficult to use. There's a lot of formality. The banks are looking for very specific, they're looking for a precisely drilled round hole to fit a precisely fabricated round peg. If there's the slightest thing out of turn, it's going to get tossed out and you're going to have problems. The law changes with great frequency. Since 2009, the power of attorney law has undergone 3 significant changes, and they've changed not only the form, but the function of the power of attorney. So back in 2000, if the power of attorney was silent on certain things, that meant you could do it theoretically, meaning let's say gifting or changing beneficiary designations or adding joint account ownership, making a TOD or a POD on an account. Now, those are what are called hot powers. If the document is silent on beneficiary designations, for example, you can't do it. That was a big change in 2015. In 2021, in January, there's another change about digital assets and how to access things like online banks. You know, a lot of banks are online only now. Capital One, you don't walk into a Capital One branch. How to access things like LinkedIn and Facebook where there are digital assets there. So the law is always changing. But with trusts, the law is much more settled and less likely to change. Then you have family dynamics. If you have dueling children, you name your son as your agent or power of attorney, your daughter is a bad egg and she exerts undue influence or convinces mom to sign a new POA, now you've got dueling documents. It's not as easy to do with a trust because trusts by nature are more protective. So when you're thinking about things here, you want to look at family dynamics, concerns about changes of the law, and the difficulty with the use of power of attorney. That being said, I want to be very clear. There is no excuse not to have a POA. You have to have one.
Yeah, it's great. And the bank, I'll tell you, I worked at Wachovia, which became Wells Fargo, and my experience was that, and I saw this just time and time again, someone could walk in with a properly executed power of attorney on a legal document and everything looked appropriate to me, and we would submit them to the legal department at the bank, and that would take weeks, often weeks. And
particularly Bank of America, Wells Fargo, Wachovia. Well, Wachovia is Wells Fargo now, but those larger banks. I work with a small bank in Warminster. I can fax a POA and they have it on file in 10 minutes.
That's great.
You want to go to a major regional or national bank, you need to have the original document, which they're not allowed to request. Yeah. You don't have to have the original, it can be a copy, but they can insist on it because you're never going to do anything. No one's going to go to court over this, even though you're allowed to. No one's going to hire a lawyer to go sue Wells Fargo to accept the POA. So you have to jump through all their hoops.
Yeah, and one of the hoops is typically, well, this is all well and good, but we need our own document, right?
Yep, always. That one pager or the front and back.
Yeah. And so that's fine. And I talk about this in the class. Do these things before you need this agent to come in and work for you, because otherwise you kind of get caught in this quagmire of not being able to get things done. Either it's a delay, or sometimes they just won't.
That's a perfect word, a quagmire.
Yeah.
If you have powers of attorney, they should be on file at the banks. I mean, if you have it executed, you should, as soon as you sign it, you should go to the bank and say, here's my power of attorney. And I acknowledge the next objection is, well, why would I put someone on my accounts to manage my affairs if I can do it myself? If you chose a trustworthy agent, they won't do anything unless they have to.
Yeah.
If that's a concern, that they're going to access your funds inappropriately, you chose the wrong agent.
Yeah, and there's a whole, as you know, there's a bunch of other liability reasons that you don't want somebody else in your account. You know, as far as creditor protection, taxes at times. So, you know, there's that gets messy too, because you do hear that often. Okay, good. That's really interesting. All right, moving on to the next slide, I'm assuming.
Yep. So moving on, we've got wills. You can go ahead and hit all the bullet points there. So a will distributes your wealth at death. That's all it does. It's got three players. The testator is the person giving the assets away at death. The executor is the one who's carrying out the wishes and distributing those funds, and the beneficiaries receive it. You may have a trust inside your will called a testamentary trust. It's a different discussion for a different day for a totally different purpose. But what is commonly misunderstood is what a will does. A will is the last resort when it comes to distributing your estate. Everything else supersedes it. And what do I mean by that? A will only distributes probate assets, and those are assets held in your name alone with no joint owner, no beneficiary designation. So retirement accounts, IRAs, 401ks, 403bs, life insurance, annuities, jointly owned assets like husband and wife, those will all pass to the co-owner or the beneficiary regardless of the will. So if I executed a will today that left everything to Mark and I died, everything still goes to my wife because I don't have any assets in my name alone. So it's commonly misunderstood what a will actually does. Like I'll hear people call, I've had families call and say, listen, my dad is thinking of selling his house, but I get the house in his will. I was like, well, that doesn't matter. A will doesn't affect anybody's ability to spend their assets. It's just a statement of intent after death. If he doesn't have that house any longer, the kid who was supposed to get just doesn't get it. So the will is last resort. In a perfect situation, you will not have a need for a will. There is a way, and Mark talks about this at great length. TOD, POD, ITF, beneficiary designations can, in large part, eliminate the need for a will. But Mark, what's the number one biggest asset people have that you can't designate a beneficiary on?
I'm assuming your home or other real
It's their house.
Yeah.
It's their house. And that, again, is one of the reason for my evolving viewpoint. In Pennsylvania, you cannot prepare a beneficiary deed. Some states have this, where you can actually do a TOD deed. We don't have that. So if you own a house, whether it's joint or just yourself, at some point that house is going to be in the name of one person. And when that one person dies, you have to go through probate. There's no question. And Mark, let's go to the next slide. We'll talk more about probate.
Okay.
So probate is just the official process of proving a will. It means you take the will to the Register of Wills in your county where your loved one or your acquaintance died, and you, as the executor, receive a document called a short certificate. It's a piece of identification. It says you can conduct the affairs of the estate. That is the starting gun. That's what starts the whole process. You now have this short certificate. What do you have to do? You got to create an estate account. You got to get a tax ID number. You've got to publish a notice of the individual's death in 2 newspapers of general circulation. You got to send out notices to the beneficiaries. You've got to do an inventory. There's all these things, all these formalities that you have to stick with, many of which you still have to do with the trust. But until you raise probate, you don't have access to any funds. You don't have access to any estate or probate funds. And there's a probate fee. There's a cost. It's not significant. It's based on the size of the estate. At most, a few $1,000s. So don't be terrified of the expense. And remember, the cost is paid by the estate. So it's money that you're essentially your heirs, your beneficiaries are paying the fee. So don't worry about how much it is. It's usually not that costly, but probate is a public process. Again, that's nothing to be scared of. Everyone always says, well, you need a revocable living trust because otherwise your probate process is public. That's meaningless. Unless you have your net worth published in your will, no one is going to necessarily know how much you're worth. The will is public, meaning they could see if you disinherited somebody. They could see who your beneficiaries are. They could see what you own based on the inventory that's filed. But that inventory can be misleading because it often only lists probate assets. So the public side of it should not fear you that much. But the reasons to avoid probate: it's lengthy, it's time consuming, it does have a cost. And again, with the COVID concern that we've just gone through, this pandemic, I watched as families couldn't raise probate. They couldn't access funds to pay taxes, like inheritance taxes and real property taxes. They lost out on a discount that the Commonwealth of Pennsylvania offers to prepayments, estimated early payments of inheritance taxes, 5%. And for some of these estates that had like 50, 60,000 in taxes, it was real dollars. They lost out on that because the Commonwealth wasn't waiving the requirement to file the tax return and pay the taxes. So while probate isn't that difficult and avoiding it is not entirely impossible without a trust, I have encountered that, particularly with real property. I'm offering it to families today, saying, here's the risk. Here's the cost of probate. Here's the cost of the trust. Here's the probate process. Here's the trust process. Here are the benefits and the detriments so you can make up your mind.
Yeah, so I always use the example. I have one of my favorite financial planning and just transfer of assets story is one of my first clients came to me and we talked about what his goals were for his estate. He wanted to leave $400,000 to each of his kids. He had twin girls and then another daughter. So he said to each of my girls, I want to leave $400,000. And because that's what his mother had left him. Well, when he passed away, he left about $1.3 million to each. So that is a big win from a investment management and financial planning point of view. But most importantly, we passed most of those assets in about 30 days. So when we were talking on the phone a few weeks ago, Bryan, I said, I've been guilty of TODing and PODing too much. And that was one of the cases where we had POD'd and TOD'd most of the funds and we had to pull some back to pay the estate tax, which was fine because everybody got along okay, but it could be problematic.
Well, you touch a very good point there. It can be problematic. Yeah. I'm dealing with a situation now where a niece received a significant IRA. It was like $450,000, $500,000. And the rest of the estate is probate. She's refusing to cooperate with inheritance taxes. So we had to request separate billing. It can become a problem. Okay. There's no question there, but you can avoid those problems with the right planning. So I don't think you over TOD'd. I don't think you can over TOD, but I acknowledge there can be a concern there. Sure.
Yeah. And I appreciate that. Thank you. But the moral of the story is that they had a property in another state. So they received the vast majority of their assets, 95% certainly all the investment assets within 30 days. But they had a property in another state that took them about 3 years to probate.
So was it Florida?
It was Maine.
Okay. This is a takeaway. When a family comes to me and says, I have real property out of state, I don't care what state it's in, I always recommend an RLT because Maine's a perfect example, 3 years. Florida is very difficult when it comes to probate. New Jersey's easy and it's not a whole lot of work, but you want to avoid having to raise probate twice or even once potentially. Mm-hmm. If you have out-of-state real property and you don't have a probate estate in Pennsylvania, do the trust. Avoid doing probate entirely as well. But certainly if you're going to have to raise probate in 2 states, you can avoid it with a trust. And that will save a lot of expense and time.
Yeah. And, you can't dismiss the emotional effect. So families get disintegrated through the estate process sometimes, and it's terrible.
Yep.
And communication is always very, very important in the case of the grantors, the people that passed away. I think it's always good to communicate with your family to your level of comfort. And I always invite clients to bring their families into the discussion with their level of comfort. But when something drags on for 3 years, even 18 months, the average in the greater Philadelphia area is probably about 18 months, right, Brian?
I agree. I prepare clients for 18 to 24 months. That's right.
Yeah. So when something drags on for that period of time, it just allows for pockets of conflict.
Mm-hmm.
And you typically have one person who's the executrix making the decisions. And sometimes he or she is making what they think are the best decisions, but suddenly their siblings, their family members who are very close to them become very, very picky and very difficult. So part of me thinks, and I hadn't thought about this really about the RLT before tonight, but part of me thinks that the faster you can get that done, the better to maintain
right.
the family dynamic. Because that's the worst thing. I don't think any parent goes to this saying, well, listen, I'd like to leave my kids $1 million a piece or $500,000 a piece, but I don't care what happens to their relationship, just as long as they get the money. Nobody says that, right?
And Mark, I have this client, this family I was working with. I think they first came to our office in 2015 for elder care planning for dad. He was living in his house. They needed care coordination. We did some veterans benefits planning for them. He died with about, I want to say it was less than $300,000 at the end when it all was said and done. 4 kids. To this day, it is still tied up in litigation because of a sister she passed away. She died during the litigation, and it still isn't wrapped up because of just petty animosities. There's nothing behind it other than just she was disagreeing with the choices of her brother and sisters.
Yeah. That's
4 years, 5 years in litigation, and it never was resolved.
Yeah. Yeah. And not to get off topic a bit, but that's why I teach that fiduciary responsibility topic during the CLEs, because I think it's so vitally important. When you're a power of attorney, when you're executor, when you're a trustee, you have a fiduciary responsibility that's not unlike mine or yours.
That's right.
And people don't realize. So I have a whole education process I go through with people who are powers of attorney, trustees, executors, so that he or she understands what their requirements are. And so much of that responsibility can be assisted because you can't abdicate it, but you can get assistance with it just by documentation. So from an investment point of view, I've had people question, well, why did you buy Apple? Or why didn't you buy Apple? Why did you do this? Why didn't you do that? And if you don't have a good answer for that, it's not making a bad decision. It's really not having a process for that decision. Mm-hmm. I just think that's so important. And so many people are thrown in these situations of powers of attorney, trustees, executors, and particularly the first two, power of attorney and trustee.
Those are the heavy ones. There's no oversight.
There's no oversight, and they often don't know.
That's right.
That they have that responsibility until that person passes or becomes incapacitated, and then they're stuck with it, right? And they have to figure it out. So, okay, sorry to interrupt.
Oh no! Look, we can go down any rabbit hole. I could talk about this for all day long. Let's go ahead and skip to the next slide.
Okay.
So the Revocable Living Trust. Now we're there. We talked about the basic documents. Now we're there. A trust is a bucket, and a Revocable Living Trust is specifically designed to have all 3 players benefit each other. So a Revocable Living Trust is this bucket that we create, and it can own anything with one exception. It cannot own retirement accounts. That's the only thing that can't be transferred to a trust of any kind. But it can own annuities, life insurance policies, cars, houses, checking, savings, CDs, everything else, investment accounts, anything else. And you all out there, if you decide to do this, you are the creator, the settler, or the grantor. You're the one creating this trust. And you are writing the rules of this trust, and it is for your benefit. So you are creating it for your own benefit, and you're designating trustees. We're going to spend some time here tonight. The trustees are often the creator and the beneficiaries and the trust, because it's all circular. This is not an asset protection vehicle. It's not a way to it's not necessarily a way to create dynastic wealth. It is a will substitute and an estate and financial management tool. So they're primarily used to avoid probate, protect your privacy, and more easily manage funds during periods of incapacity. That's where I want to focus. We've already talked about avoiding probate. We've already talked about how COVID threw that for a loop, but more easily managing funds. So when you create this trust as an RLT, under almost every circumstance for what we're talking about tonight, you guys out there, you will be the creator, you will be the beneficiaries. You don't have to be. We can do it. You can make it dance. The trustees may differ. So you will most certainly be one of the trustees, but if you name your adult child, or you name your spouse, or you name your brother, or whomever you would designate as your agent under power of attorney as your co-trustee, once the trust is created and funded, you no longer have to worry about that person, that trusted person, assisting you with your affairs because they're already the trustee. They have the same access to it as you would. You've overcome those concerns we've talked about with power of attorney. You've overcome the concerns about, well, what if the law changes? What if my documents are really old? What if I can't find the power of attorney? The trust is already there. The trust is always intact. And Mark and I were talking about this before we got started. What do you think about doing another poll?
Yeah. And we have a question that I think is important. So Don, thank you for bringing this up. We're throwing around these terms TOD and POD, and I don't think we gave it a definition.
Oh, it's a great question.
Yeah. So a TOD is a transfer on death. And you generally find that with investment accounts, transfer on death designation. It's a separate form you fill out, and you essentially list beneficiaries on a non-IRA, non-annuity account. POD is payable on death, and that's generally found in banks and bank accounts where you name beneficiaries. So, Bryan, did I explain that correctly?
Absolutely. And then the final one, occasionally, you see this infrequently now, is ITF.
Okay.
In trust for. I don't see that as frequently, but they're almost all distinctions without a difference. The reason I think the distinction between TOD and POD is important, when you have an investment account, you don't necessarily want it to be liquidated and sold for cash. You may, but you may not. Transfer on death means you can transfer those exact holdings to the beneficiary. Pay on death generally means you get a check for cash. That's the only real difference there. It's exactly right, Mark. You hit it dead on.
Yeah, most investment firms are up to snuff on the TOD, the transfer on death. It's questionable whether your bank is going to understand it if you go in to the bank, if you have the opportunity to go into the bank. Because for many years, I've been saying this. Unfortunately, the banks are really stretched as far as personnel, and the teller might be doing the banking job as well. And if you ask them about PODs, they might say, "I don't know what you're talking about." Mm-hmm. And I would often say, sometimes you have to ask a manager. And I used this example in one of our classes, and at the second class, a couple came up and said, "We went to our bank, TD Bank, and they did exactly what you said." They said, "No, I think we used to do those POD things, but we don't do them anymore." And then they sent me to the manager, and the manager said, "No, we don't do PODs, but if you buy an annuity from us, we'll be able to name beneficiaries, and that's the only way to avoid probate," the manager told them. So I said, "Listen, first of all, there's nothing wrong with annuities when being used properly, but that is not the reason, right?" And
yeah,
I stood
you
there.
should put your money in a life insurance policy so you don't have to worry about probate.
Goodness gracious.
Not the best advice.
Well, yeah, there's a lot of good reasons to use these vehicles, but not for that reason. So I actually stood there in class, or at the beginning of the class, and I pulled up TD Bank's POD form on the website for him, and I emailed it to him, and it's just as easy as that. So sometimes you have to dig. So good question, Don. Let me see if there's any.
And Mark, that's good planning. It doesn't always work. If you're leaving resources to a disparate number of individuals, you might not be able to use that. But in a traditional, typical sense, I would say 80% of my estate planning clients are all to spouse, then to kids equally, maybe 70%. Mm-hmm. In that circumstance, TOD works very nicely. Mm-hmm. And also, I saw someone commented in support of the use of TODs. I think was it Marvin?
Howard?
Howard, yeah, he said he couldn't have backed you up anymore. He said he was able to distribute funds on his, I think it was his mother's death,
Yep.
in a week because of TOD.
Yeah.
Got the 5% discount. It was it worked out perfectly, exactly as it's supposed to.
Yeah. 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 Good comment, Howard. Malcolm's asking, Brian, if you could please confirm retirement accounts and RLT. So I think Malcolm's asking about the point you made, and Malcolm, you can send us another note if I'm misunderstanding this, that you can't put retirement accounts in a revocable living trust.
Correct. And I mean, you could, if you're willing to liquidate them, pay all the income taxes in one lump sum and then move it, but you're still not doing it. You're just moving cash. So an individual retirement account of 401k, 403b, 457, whatever that is, all of those have to stay in an individual's name. They cannot be owned by more than one person or by an entity other than a person.
That's right. And you can name Malcolm, you can name a trust as a beneficiary of an IRA.
Mm-hmm.
And
right.
there used to be some really good reasons to do that from a stretch IRA point of view.
Mm-hmm.
But we all know that stretch IRA doesn't exist anymore.
That's right. The Secure Act really, really shrunk the reasons for that. There, you can still do it, but you're going to get pretty disfavorable tax treatment if you name a trust as the if you name a trust as the IRA or
beneficiary.
A trust as the beneficiary.
Yeah. Yeah, it used to be really, really great and interesting planning to do that. And it's like Brian said, the Secure Act took that away really quickly. So Howard also asks, if Brian does not plan to cover in his talk, he's got 2 points. Who should be successor trustee, corporate versus friend family? Great question, Howard. And then 2, any downside to an RLT other than not transferring assets to it once created?
I mean, Howard, if I didn't know better, I'd say you were a plant. So the successor trustee, I generally don't advise a corporate trustee. Most financial advisors won't do it. They're not usually allowed to as through compliance. If they could, I would love it if it was your financial advisor, just because you have a relationship with them. I recommend a family, a friend. The reason I'm not a big fan of corporate fiduciaries is because most of the time, if you're appointing ABC Bank or ABC Bank's trust officer, all the resources have to be in the bank. And the concern I have with that is you're kind of serving 2 masters. The trustee has an obligation to distribute funds according to the terms of the trust, but the bank has an interest in keeping the money in the bank. And I don't see how you can reconcile those 2 things. I've had a lot of bankers and trust officers really argue that point with me. It's my own personal opinion. There's no illegality to it. I just think there's an inherent conflict of interest there. The downside to the RLT, you hit it. Not transferring assets once it's created, that's the biggest mistake people make. They have this, and Mark, I want to take a moment and talk about this because back in the 90s, those trust mills, remember those guys that would go house to house and sell those big binders of trusts?
Yep.
I see probably 10 or 20 of those a year, and the trusts are never funded because the advisor doesn't carry the ball. They say, sign it, here you go, you're off, go fund the trust. Those gave RLTs a bad name, and I think that's why people look at them with a little bit of a side eye. But they do have a purpose, and if you fund them correctly, I don't see a downside to them. I think if they're funded correctly and you put the resources in that you need to, you're in great shape.
And you may touch on this, but you talked about naming co-trustee, beneficiaries. Mm-hmm. The key point here is it's a revocable living trust. You can change this at any time, right, Brian? You
can change it until the day you die. You can change the beneficiaries, the trustees, or just collapse it.
Yes.
You can revoke it and take all the money back. So let's say, for example, and this could happen, you appoint yourself, you're a single individual, and you appoint yourself and your son as co-trustees, and your son have a falling out. You don't need to rely on your son as a trustee to distribute money to yourself. You're not giving up you're not abdicating any responsibility, because you can revoke the trust and say, it's my money, I want it all back. You don't need your co-trustees agreement. You only need the co-creators agreement. So if it's a husband and wife, you both have to agree to it. And if there's concern about that, family dynamics, husband and wife, maybe you're worried about a divorce on the horizon or some sort of other family dynamic, you create 2 trusts.
Mm-hmm. Yeah, great point. So just two more questions and then we're going to close this for a bit. And I'm going to see if I can launch the second poll. I
Sure.
haven't always had success on the second and third polls, so we'll see how it goes. So Andrew asks, how do you do an RLT with online banks?
It usually isn't that difficult. It's no different than, so most online banks, you're still talking to a person. So you can make a phone call, but it's no different than opening another account. And that's actually a very good point. I think it was Andrew that said this or asked this question. When you're transferring funds into an RLT, occasionally, but rarely will the bank let you transfer the actual account in. You're most likely to get new account numbers. Mark, do you agree with that?
Mhm.
So let's say you have checking, savings, investments, 1, 2, 3, 4, 5, 6, 7, 8, 9. You shift those in, it's going to become 12, 13, 14, 15, 16, 17. So there can be some nuance there, but you're really not transferring accounts, you're transferring funds. So you would go to an online bank and say, here's the trust, here's my social security number, here's everything to do, open the account. Then you would transfer funds from one account into the new one.
Yeah, and I just want to step back for a minute because Brian made a good point, or someone did, about titling. I guess it was Howard's question about what's the downside, and that is just such a huge downside that somebody goes to the time and the expense and the effort to create a trust, and over time, things just aren't titled in it, and it can happen many different ways. You buy a new property, you move, and you decide not to. Nobody reminds you to retitle the new property into a trust, and um, financial advisors tend to jump around to different firms, and I've seen it where my person used to be at Payne Weber, then they went to Wachovia, and then they went here, and somewhere in that mix, the title of the trust came off of the titling of the account, and suddenly it's John and Jane Doe, joint tenants with rights of survivorship, which isn't what you want it. So everybody in class that have taken my classes or watched my webinars can probably say what I'm going to say already, but you should review these things every single year. There's no redundancy. It's not too much. You should review these things every single year because things get dropped. Sometimes there's just errors at the institutions, and it's really important
and things change.
And things change. Yep.
You might have a new addition to the family. You might have changed jobs, gotten divorced, gotten remarried. You want to look at these things.
Yeah.
There are risks, some plans, not others, but you could name your ex-wife as an IRA beneficiary or your deceased spouse as an IRA beneficiary and forget to update it if you get remarried, or forget to update it with your children. That can create a real problem, particularly on the tax side of things, but even on who gets the assets.
Yeah. Yeah. And I have a personal story I tell all the time in class about that I'm not going to tell tonight, but not all attorneys are thorough like Brian is. And I know Brian's one of the few attorneys that meets with his clients every year to review their estate plan. And that's nearly unheard of. Most attorneys are very reactionary, and that's okay, right? They respond, or they're there if you need them.
Correct.
But Brian and his team, they review these with clients every single year, and that's nearly unheard of.
The problem with this area of all this planning, whether we're doing estate planning, asset protection planning from long-term care or care coordination, the law is always changing. The Secure Act, that was a major upset. We have an obligation to sit with our clients. The digital assets that are changing, I have an obligation to sit with them and say, we got to update these things. We sent out about 24 letters to families that had used those conduit trusts, Mark, saying your plan doesn't work anymore. It's pointless. It's meaningless. You need to figure out another solution.
Yeah, great point. So so I'm going to read these few, just three things here. So Howard has two comments. So Howard is probably the most well-read student I've ever had in class.
No kidding.
He really knows what he's talking about. I named a charitable remainder trust as beneficiary, in brackets or parentheses, tax-free of my IRA to continue to pay my wife until her death. Brilliant planning. That's exactly
very good planning, particularly if you a charitable remainder trust is a particularly good option if you don't have multiple successor beneficiaries. If you want to provide for your spouse and that's it, or then the charity becomes the sole beneficiary upon death, it's a great option. And it also can really reduce, you're giving whole dollars. That's actually a good planning technique. If you have 100,000 in IRA and 100,000 in cash, and you want to leave money to a charity, you want to leave half of your estate to charity, leave the IRA.
You're darn right.
They're going to get that tax free. You want to leave the cash to your beneficiaries because they're not going to pay any income taxes on it.
You're darn right. Yep. Yeah, that's really good planning. And I think we reviewed that, Howard, when we were together. So Malcolm asks, what is the time limit to access the 5% discount on PA estate tax?
3 months from the date of death. You got to file an estimated prepayment, and you send the check up. You're either going to hit it right on the head, you're going to overpay or underpay. If you're not raising probate, listen to me very clearly. If you are not raising probate, you want to underpay the tax. Because if you get a credit, it's going to be payable to the estate of, and you've got nowhere to put those dollars.
Yeah.
So you want to underpay the tax and forfeit a little bit of the discount so you don't run into a problem where if you overpay, you can't deposit the funds anywhere.
That's great advice right there, folks.
That's key. And believe me, that was learned the hard way by yours truly many, many years ago.
Yeah, that's great advice. Okay, Howard has another question. What about use of trust protector?
So let me talk about what a trust protector is, then I'll talk about when you use it. So a trust protector is a fiduciary. It's somebody who is independent, and you appoint them to oversee management of the trust. I serve as trust protector in the irrevocable trusts of the families I work with. Irrevocable trusts serve an entirely different role, because once the grantor, the creator, the settler, once the creator puts money in that trust, they can't get it back. And they have no oversight. They're not the trustee, they're not the beneficiary. It's an asset protection tool. So I want my families, I want my clients to feel comfortable with that, knowing that I'm overseeing management of it. I can make sure if the trustees start doing the wrong things, I can remove them. If the law changes, I can make a revision to the trust to make sure that the trust can accomplish the goals that my client articulated in the first place. If there's a Scrivener's error, sometimes we write something, it's ambiguous, and we visit it a couple years later, we think, that's not as clear as it should be. I can revise that. The reason I recommend them in irrevocable trusts is because the grantor is giving away all control. Mm-hmm. With an RLT, you don't need that level. You don't need that level of protection because the grantor maintains so much control. They can make changes to the trust whenever they want to. They can move money in and out. So I don't advise it as necessarily while the grantor is alive. You may wish to appoint a trust protector that starts to serves after the death of the grantors, just to make sure everything is administrated properly upon the death of those creators.
Because isn't it fair to say that the revocable trust becomes an irrevocable trust once the grantor passes, right? I mean,
essentially yes.
Yeah,
but it's a little more nuanced. You're exactly right, because the rules lock in.
Right.
Meaning once the grantor dies, nothing can really change. Yeah. But many times these RLTs, they pour out. So you die, it all goes everywhere. So if you have a trust protector, it might be just for a very short period of time, but you can create dynasty trusts. You can say, here's my RLT. I'm going to fund it with this money. And when I die, there's another trust in there for the benefit of these people. And then when those people die, there's more trusts. There's more additional successor and contingent beneficiaries. That may be the need for a trust protector more readily than when the grantors are alive.
Yeah, great question. Great question.
It really was.
Let's try this poll. Let's see. So we're going to relaunch polling. Let's see here. Oh, no, that's the same question. What legal documents do you think are important? Okay, everybody's voting again. I appreciate that. Let's see where we have two other polls. All right, Brian, you keep talking. I'm going to dig into these polls here.
You got it. Let's go ahead and skip a slide forward.
Okay.
I think this might be, if memory serves, it might be our yeah, we'll go ahead even one more, just hit me all those bullet points there. So revocable living trust, why and when? I already mentioned out-of-state real property. Now, if it's New Jersey, not as big a deal as if it's Florida, California, and now I know Maine. Thank you, Mark. Also, family dynamics. Trusts are generally more difficult to break. And what I mean by that, I had a situation a few years ago. Wife was the agent under power of attorney for her husband, and I didn't prepare it. They came to me this way. Husband was had dementia and Parkinson's that had progressed pretty significantly.
Mm.
Out of the blue, a nephew comes in and says, I want to be my uncle's agent or power of attorney, had a lawyer prepare a new POA, started accessing funds. Not proper. All kinds of problems here. The issue was when we went to court, we had dueling POAs, so we had to have a guardian appointed. It took years and cost close to $600,000 in all kinds of legal fees. There's so much here. Someday we'll have a whole separate webinar. I'll tell you just this story. It's absolutely fascinating. It would take 2 hours.
Guardianships are terrible.
Oh, it's terrible.
Yeah.
There was divorce. It was crazy. I mean, this was like a soap opera.
Terrible.
Had this all been in a trust, it would have been much, much, much more difficult to break because of the nature of a trust, the nature of what you do with a trust, the nature of trustees. When it comes to accessing funds, there's ease of access to those funds. If that's a concern of yours, you want to consider an RLT. And again, if you want to avoid probate, I have families, when I sit with them, I say, here's the cost for probate, here's the cost for a trust. And they say, oh, you know what? I don't want my kids have to deal with it. I'll bear the cost today. An equal number of people say, nah, let my kids pay it. They're getting an inheritance. And it's up to you. I will never insist on a trust unless there's unique family dynamics or out-of-state real property. Those are the only 2 times I really insist on it. Other times I offer it, just like we discussed today, and let you make a value decision.
Yeah, good. Okay, I figured this out with the polling. Do you want to launch the poll now?
Oh, yeah.
Okay, so this is our second question. So the question is, what documents do you have? You told us, all of you agreed that all these documents are important. Now the question is, what documents do you have? So let's see what everyone says. Put your money where your mouth is, so to speak, right?
Yeah, yeah. Particularly now, I think we should have done this right off the bat, because everybody's going to be too scared to tell the truth if they don't have
You gotta
everything.
be honest. Listen, first of all, this is anonymous. I should have said that. We made this poll, and the next one, the first one, that might have been anonymous too. It doesn't matter. But this one and the next one is anonymous. So we can't tell who's saying. So be honest with it. Okay. 3 participants raised their hands. Are you raising your hands to tell us you don't see the poll, or raising your hands to tell us that you? Okay. I'm not sure what that's about, but if you're not seeing the poll, you can put it in the questions. But we have 71% are saying they have a will and a power of attorney. Only 18% has a will, power of attorney, revocable living trust, and a living will. So, and 12% have a will. We're not going to ask who doesn't have a will. So now the next question, let's ask the next question, and I can share these results, and then we'll relaunch. Hold on, let me polls.
Very interesting.
Yeah. Yeah.
Very interesting.
What are you finding interesting?
Well, I'm interested. It's interesting to me that I'm always baffled, unless you did the will by yourself, meaning online, or you hand wrote or you typed up yourself. I'm always baffled when families come into my office and say, here's a will, and I can see it was prepared by a law firm. And I say, where are the powers of attorney? Oh, we didn't do it. To me, it's part and parcel. That's like someone pulling up and saying, not having doors on their car. I'm saying, well, what happened? Oh, I didn't buy the door. No one offered me doors. That's it. You can't do one without the others, in my opinion. I think you need all those.
Well, Brian, you're a lot younger than I am, but it used to be very common when I worked at the bank in particular, and before that I was at UBS. People would just have a will, and I would often say you got to have a power of attorney and possibly a trust, but now it's very common to see those documents, that set of documents, instead of just,
no one ever says, what do you charge for a will? No one ever says, do you do wills? They say, do you do wills, powers of attorney? They say, what do you charge for wills, powers of attorney? They say, can you put this package together? And they should. To have just a will, it's almost meaningless. The chances of you having some sort of cognitive incapacity, having a stroke, having multiple sclerosis, losing the ability to manage your own affairs, 7 in 10 in Pennsylvania are going to require some sort of long-term care. That doesn't mean you're going to lose your faculties, but it means you're probably going to lose the ability to run to the bank and pay your bills.
Sure.
7 in 10. Just remember that. And to not plan for that, you're setting yourself up for failure. And it really worries me. I hope everyone takes away from that today.
Yeah, it is vitally important. Okay, here's the third poll. So now the question is, how old are your documents? Again, this is anonymous, so you can be honest. So the first multiple choice, less than 5 years, 6 to 10 years old, 10 plus years old, or who the heck knows? Be honest.
And I think it goes without saying that who the heck knows means it's way, way older than 5 years.
You're way older than 10 years.
Yeah.
You know, and the funny thing is that typically, and we were talking about this before, when I ask people, do they have a will and legal documents, they either say yes or no. And it is surprising how many people say no. But when they do say, yeah, I have a will, and I say, well, who did it? And they'll say, it was that guy in the corner in Doylestown or Princeton. And I would say, what's his name? I don't remember his name. And then of course I ask how long ago it was done. 5 years ago, maybe 10 years ago. And then they bring in this document that's 25 years old. It's completely, I had one client who said, yeah, I got a will. Many of you have heard this already, but I'm going to repeat it. I have a will. It's in my dresser drawer. I'll bring it in. Well, it was drafted on, remember that thermal fax paper that used to be way before Brian's age, Brian's time, but it's
I know what you're talking about.
Yeah, you think so. It was this faded mess of gray letters that nobody could read. And Jessica, from my office manager, tried to darken it on the copy machine and just couldn't get it done. And this woman had no will. She had a document that meant nothing. So let me see here. I'll end the polling now. I'm going to share the results. So less than 5 years is 58% of you. That's great.
Nice work, guys. Yep. Nice work.
Really nice work. 6 to 10 years. Howard's in that group, right? 6 to 10 years is 26% of you. 10 plus years is 11%. And who the heck knows is 5%. So really, really interesting.
So why do we ask that question? I think we've kind of threaded it through our whole discussion tonight, Mark, but just on the power of attorney side alone, the law changes so frequently. You want to have things that are up to date. It's like your iPhone or your Samsung. You're constantly updating the software. This is your software. This is your legal planning software. You want to keep updating those things. So I'm not saying just because it's 5 years or 10 years old, you have to get it updated. I'm saying you should have it reviewed. Because I've had powers of attorney come to me that are 10 years old. They're fantastic. They were almost prescient looking. They were almost clairvoyant looking into the future. And I've had ones that are 2 years old. They're terrible and essentially unworkable. So I'm not saying you have to get them revised just because of their age. I'm saying get them reviewed because of their age.
Yeah, and I agree with you, Brian. And that goes back to specialty, right? So you don't listen. If your brother, cousin, friend is counsel at Amazon, and you ask him or her to do your will, you're probably not going to get a great will or legal document. You're probably going to get about the same that you would get off of like LegalZoom, which I never recommend, by the way.
Mark, it's funny you say that. I met with a family today. Her brother is a district attorney out of state, and she did the document, or the DA did the documents for her, and she goes, I knew he didn't know what he was doing. And I was like, yeah, it's not good. But I wouldn't go try a criminal case. The guy would go to jail. Yeah. That'd be it. He'd be in jail for the rest of his life. Or I'd lose. So whatever they do, I would lose.
Yeah, you gotta have your specialist, and any, how do I say this without being offensive? The people that aren't specializing should know that and be able to tell you that, right? And because it's not about saving a couple bucks. It's about making sure your things are done right.
Yeah, so somebody comes to me and says, like, can you help me with the real estate deal? I say, no, call this guy.
Right. Yeah. All right. So that was fun. That's it for the polls tonight, folks. So a couple questions. Andrew asked, can a revocable living trust work with a special needs trust too?
Not off the bat. So for those of you that aren't familiar, special needs trust is a specific type of trust that is designed to preserve an individual's eligibility for public benefits, such as Medicaid, supplemental security income, and other types of public benefits. Those are means tested, which is a fancy way of saying you can't have any money and still qualify for them. A supplemental needs trust, Andrew, could be a sub-trust of an RLT. So let's say I'm a parent and I have a special needs grandchild, and I know my grandchild is going to be on Medicaid. I can create the RLT for my benefit. On my death, everything can go into the SNT, Supplemental Needs Trust, for my child. But if I were disabled and I wanted to create a supplemental needs trust for myself, I could not use an RLT. I would have to use a very specific type of special needs trust called a first party or D4A trust. They're very, very, very specific, and they're typically used in two circumstances. When you're injured on public benefits, you can get a lawsuit settlement, or when you're on public benefits and you receive an inheritance. Those are the two biggest reasons that we see SNTs being used, first party SNTs.
Okay, really good question and good answer, Brian.
Yeah, indeed. Very good question.
Teresa asked, I need to update my will and other documents, and I'm in New Jersey. Do you represent clients in New Jersey? We have been talking a lot about Pennsylvania law, and I do know Brian has multiple offices in New Jersey, so I'll let you talk about that, Brian.
Oh yeah, we have as many offices in New Jersey as we do in Pennsylvania. We help clients on both sides of the bridge, and I'll be able to advise you on New Jersey estate, inheritance tax, transferability issues, just the same as I would in PA. Absolutely. Feel free to give the office a call.
Yeah, and I think Brian's last slide is probably his contact info, and you'll all get an email tomorrow that'll have Brian's contact info as well. Howard asked, so it's okay to have an estate lawyer being trust protector?
Oh, absolutely. There's no I routinely serve as trust protector, agent or power attorney, or executor. I don't serve as trustee. That's a more difficult. It's a more difficult role. So rarely will you have attorneys serving as trustees when they prepare the documents, only because there's a weird sort of nuance there. But I always serve as trust protector, executor, and powers of attorney when needed.
Yeah, and Brian mentioned this, and I always note this as well. If your financial planner or financial advisor offers to be your power of attorney or trustee, run as fast as you can the other way.
As fast as you possibly can.
Yeah, that's how people lose, if not everything, a lot of money. Because
if you're not paying your agent, meaning if you're not paying them for the service, if they're not a family member, run. If somebody's saying, "Oh, right," to Mark's point, I'll manage all your funds and I'll take a % under management and I'll be your agent, you want to run. I agree 100%.
Well, not to mention it's a regulatory violation. So if your planner or advisor is going to do that, he or she is suspect anyway, right?
Yeah, and I think the issue, Mark, is that there's no real barrier of entry to call yourself a financial planner. You can't call yourself an attorney unless you have a license, but there's no difference between calling yourself a financial planner and calling yourself a certified financial planner unless you have the certification. But when you are, I'm phrasing this poorly. If you have an insurance license and you have a securities license, there's no difference. You can call yourself a financial planner even if you're only licensed to sell insurance.
Mm-hmm. That's true.
If you're securities licensed and you're a CFP, you're certified, you have all these things behind you. But these guys over here with no barrier to entry, they're not subject to the same regulations you are. They're not subject to the same standards that you are.
Mm-hmm. That's right. Yeah, and just to clarify, you cannot call yourself a certified financial planner unless you're actually a certified financial planner.
That was where I misspoke. What I meant was just financial planner.
I'll make sure that you know, and everybody knows. But that is the only board certification in our industry, and that's why it's so valuable, in my opinion. Not to mention the education.
I agree.
But you're right. Even financial advisor is a very gray term, and there's been a lot of discussion and conflict about that. And thankfully now everybody, if I would have talked about what a fiduciary was 10 years ago, many people wouldn't know what that was. Because again, I was teaching about this then, but now everyone asks the question, and they should. It's very, very important. And at some point, everybody who handles someone else's money or helps somebody with somebody else's money is going to have a fiduciary obligation at some point.
Mark, touch on that one more time, just so we're clear. So you cannot be a certified elder law attorney unless you are board certified by the National Elder Law Foundation, period. Yep. You cannot put any other numbers or letters after your name. But in your field, CFP, that's the gold standard, right?
Yes.
But don't you also have chartered financial consultant and certified financial advisor? There's all these letters you can put after a CLU. all these letters you can put under after your name, correct?
Yeah, you can.
And it looks impressive, but sometimes they're meaningless.
Yeah, and here's an example: CHFC, CLU, they're big ones, and they're developed by a school, the American College, which is has a great reputation, and there's a lot of good people that have those certifications. But it is the American College that creates these certifications and creates the courses for those certifications.
And why do
So
they do that?
what's that?
Why do they create all those certifications and courses?
Well, because that's how they get their money,
There
right?
it is.
The CFP, but you can study for your CFP course through the American College or through the University of Texas or BY, any many universities. So and then sit for the 2-day 11-hour exam for the CFP exam that 50% of the people who sit for it fail. Um, uh, so that's different, right? That's the board certification. There's also a CFA, chartered financial analyst. Most CFAs, and that's also a very well respected designation. Most CFAs are the portfolio managers and the people working behind the scenes.
They're kind of on the wholesale side more than the client
Yeah,
side.
yeah, exactly,
Yeah.
exactly. And
So
there are
it just means be discerning, because that's the downside to a lot of industries. When you don't have these barriers to entry, you have to be calling yourself a financial planner is meaningless. Calling yourself a certified financial planner is gold standard, and it's one word.
yeah, true. Okay, thanks for that. Teresa says, I have a will, POA, and health directive. That wasn't a choice. The only thing I don't have is an RLT. I'm sorry, Teresa. I thought we included that, but
Yeah, I think we overlooked that.
Kathy asks, if you created a will years ago to primarily provide for care of minor children, and they are definitely not minors anymore, do you need to do something to negate that will and create a new one? Good question.
Maybe. It's a very good question. It's one of those things where I'm a fan of the most simple wills possible. That doesn't mean your will is simple. It means if you had a will that left things to minor children in what I'm guessing is a minor's trust and it's no longer necessary, you may want to revise it to simplify it. You may not have to, though. It may not be a requirement. It just might be advisable, because I want it to be as short, concise, and clear as it can be.
Okay. Good question, Kathy. Malcolm said, thank you. You're welcome, Malcolm.
Thank you.
And Andrew writes, what happens if you move your residence out of the country and want to set up an RLT with protection of assets in the USA? Can that be done?
So if you are not a resident of if you leave the country and then set it up, that I can't tell. I don't know the answer to. But if you're a U.S. citizen, you can set up an RLT. As long as you're a U.S. citizen, you can set up an RLT with your assets. I don't think there's a restriction on non-citizens doing it, but I don't know the answer to that. You can certainly move abroad and set that up. What I don't know the answer to is whether you can transfer a French countryside house into an RLT. Of course, that's French law. I don't know about transferring French assets, but there's no restriction on you having a trust here and skedaddling to a country that has certainly a better climate on a cold, rainy night like tonight.
Yeah. Okay. That's it for the question. So let's see. You have another slide or two, Brian?
I think we hit most of these. Okay. We talked about TOD, so we could probably skip all the way through this.
Okay.
Yeah, we talked about all this.
Yeah. All right, and folks, it's 7:45, so we went about 15 minutes over, but we knew that we were going to be loose on this. And by the way, great question. So I'm always really impressed. Yeah. This is Brian's contact number. So you can see Cherry Hill, Turnersville, Hamilton, Radnor, Trevose, Philadelphia, New Jersey, and Philadelphia, or Pennsylvania. And Brian is probably the only attorney I've ever heard say estates are and probate is easy in New Jersey. So so that's good. Many attorneys won't even touch it, and they'll ask what specific counties it's in, and it's kind of crazy.
And that's why we're fortunate to have a bustling practice on both sides of the bridge, because even when it comes in for those of you out there, we're also elder care lawyers, and so we work with families to access long-term care and navigate the nursing home, assisted living, the Medicaid process, Medicare issues. And the states, New Jersey's better for some things and Pennsylvania's better for some things. So we have families moving across the river all the time. So it really benefits us to know those laws and the regulations in great detail. And Mark, if you don't mind, I'd like to give my email address too.
Yeah, please.
Just if you have any follow-ups, you are all welcome to shoot me an email. The address is Bryan at rothkopflaw.com. And you see that, how that's spelled on the screen there.
Yeah, and like I said, everyone should receive at about the 24-hour mark. It's an automatic thing with Zoom. They'll say thank you for attending. If you have any questions, you can contact us. It'll have my contact information and Brian's contact information as well. And if I somehow omit Brian's email address, just write back and I'll make sure. And if you have a question, I'll make sure to get you two together. Now, when we log out of here, as always with these webinars, you'll end up at my calendar. If something piqued interest and you need to address a question for me, or you want to even connect with Brian, you'll have the ability to schedule something on the calendar for me. And again, if you need something with Brian, we can help you with that and get you two together. I don't think there might be one more question here.
It was a thank you.
Oh, that's nice. Thank you.
I appreciate that, everybody. Mark, thank you for inviting me to do this. Like I said, I could go on and on. I could talk about this all week long. So I really appreciate the time. This is a great thing. And for those of you on here that aren't aware, Mark is a veteran. So we thank you for your service as well on our Veterans Day today.
Thank you. Thank you. All right, folks, that was really fun. We'll see you on Tuesday for the webinar, and I'll let you know when the next one of these comes up as far as the special webinars, and I'm sure we'll have Brian back really soon. Thanks, Brian.
Thanks, everybody. Take care.
Take care. Bye-bye. Hello again. I hope you enjoyed the video and perhaps you learned something new that can help you. If you want to schedule time for me for a no cost, no obligation consultation, you can use the link in the description and schedule a time that works best for you. If my schedule is full and you can't find anything, don't worry. Send us an email and we'll find a time that works for you. I look forward to speaking with you soon. Thank you. Have a great day.